Hello and welcome to the top 5 tips for new litigators. My name is Matt and this is Cynthia, and we are with Elite Litigation Training, a company we started to create the classes that we wish we would have had when we were starting out. And today, we want to provide you with 5 quick, practical tips that can take your career to the next level. We don't have a lot of time, so let's jump right into it. The first tip we want to talk about is utilize jury instructions. Now, a lot of people only go and use jury instructions right before it's time to go to trial. They go, they pull the jury instructions, they retype them, and they submit it as part of their pre-trial work. But that misses a big opportunity. You know, when you hear the adage all the time of you need to know your case. And most of the time we think about that as factually, you need to know it backwards and forwards. But that's really only half the battle. Jury instructions are so critical to be familiar with at the earliest point in the case.
Absolutely. They're so key. And if you use them at the beginning of your case, they're really going to provide a roadmap for you to use throughout the entire litigation process. But jury instructions will help you regardless of which side of the V that you're on. If you're the plaintiff, they're going to spell out very clearly for you what you need to assert in the complaint. What are all the elements of the causes of action that you need to assert? If you're a defendant, they're going to set forth for you what are the affirmative defenses that you're going to want to allege or assert in your answer to the complaint. So from the very beginning, even before you even get to drafting the complaint, honestly, if you're on the plaintiff side, the jury instructions are going to help you to determine what causes of action you have and if you have enough factual support for those claims. So really, from the beginning, from the inception of a case, you should be looking at the jury instructions.
Jury instructions set your perspective, right? Because once you know what is ultimately going to have to be proven at trial, which we say trial, we're just getting started on the case. Every case needs to be prepared as if it's going to trial. And that doesn't start with pre-trial work. That doesn't start after you've done discovery. That starts at the earliest possible point. So we set our perspective immediately on what we need to do in this case, and that really changes the dynamic. And it's not something that a lot of attorneys do. You know, a lot of us fall into our own specialties and we say, okay, well, we know all these things and we have elements and we think about motions and all of those things, but sometimes we don't think about the big picture. And one of the things that we're going to really harp on today is that you need to learn how to think about the big picture. And jury instructions are the first thing that you can do to set your perspective and get yourself moving in the right way. So I like to think of printing out the jury instructions and keeping them in the file, or if I'm working on just a couple cases, maybe just keep them on your desk. Electronically, you might want to just put them in the file, however you want to do it. You could either charts or spreadsheets or whatever it might be. You just want to make sure that you have pulled and are completely familiar with the jury instructions so that you can look at those in light of the facts. You can really move the dynamic of the case forward.
And not only with respect to the elements, Matt, but jury instructions, a lot of the times are annotated. So they're a great resource as you move through the process because they might provide you with some wonderful citations to CASO, to case law, to regulations, to statutes. And instead of going down a rabbit hole of what's that one case, look to the annotations in the jury instructions because maybe it's right there in front of you.
Could be right there. So first thing that you want to do is use jury instructions. Second thing you want to do is you want to create a discovery plan. What is a discovery plan? A discovery plan is not just saying, I'm going to serve this at a certain time. No. What a discovery plan does is before you even set out drafting the discovery, we want to know exactly what we are looking for to get the evidence that we need to go to trial. And everything in the discovery plan is going to flow from that. But not just that. What we also want to do in our discovery plan is think about the discovery mechanisms that are available to us and how strategically we can use those discovery mechanisms to the best return of what we're trying to do with them. A lot of attorneys, Cynthia, they don't think about how discovery mechanisms might interact with one another. And so they miss opportunities.
They do. They really do. And the important thing is to have a sense of what is the right mechanism to obtain the discovery that I need? Is it an interrogatory? Is it a request for production of document? Is it an RFA or is it a deposition? I see so many attorneys that propound discovery and it's clear to me that they have no plan. They're asking questions, interrogatories that really should be kept for deposition. they're wasting.
Can you tell us why, Cynthia? Because this is important. And we don't think about this that often.
It's true. Well, first of all, in your jurisdiction, for example, under the FRCP, you might be limited in the number of interrogatories that you can ask. So you want to make sure that you're being judicious with those interrogatories, but also think about who's answering the interrogatory. It's not the client, it's the attorney, right? You draft a response for the client then to review and verify, assuming that the facts are true.
Yep.
But the attorney is looking at that and crafting it. So questions that are central to an issue, to a cause of action, to a defense, those are better kept for deposition, because then you're going to get the witness actually testifying and not the attorney writing out a response. So knowing when to use interrogatories, because you don't want to ask every question by interrogatory. Or you see attorneys who will spend an hour in a deposition on verifying documents when that's something that is so easily accomplished through an RFA later in the process, perhaps after an initial round of discovery.
Which can also be problematic because of this Cynthia reference. There's a lot of discovery limitations. In the FRCP, you are only entitled to so many interrogatories. In a deposition, you're only entitled to so much time. In your jurisdiction, there might be different limitations. And so you need to understand how we can use all of the discovery tools available to us to really accomplish our objective. So what we want to do is, before we draft the discovery, we want to think about what we need and how we are going to get it. What's the best way to get the best evidence that's available to us? Now,
Other thing,
go ahead.
I can.
Yeah.
Also, we want to think about the timing of it, right? Because if we're in federal court, we want to see what we're going to get in initial disclosures. We might not want to use RFPs or interrogatories for information about witnesses or documents that we might get through initial disclosures. And if your state jurisdiction has initial disclosures, that's another thing that you factor in with respect to timing of using those discovery mechanisms.
Yep. And if you're a solo practitioner, you're going to go out and you're going to hang your own shingle. You're going to have to figure out how to do these things. And a discovery plan can be particularly important because your time is so valuable. And you need to make sure that you're judicious and efficient in everything you're doing. But let's say you're at a firm. Can we take a second and maybe do a little role play here?
Sure.
Okay, so Cindy, you were an equity shareholder in Nationwide Law Firm.
Wow.
All right. So you play that role again.
Okay.
If you have to. And I'm going to play the new attorney that is the firm.
Okay.
What happens if I come to you? You've asked me to draft discovery, and I come to you and I say, Cynthia, I've actually put together this discovery plan. Can we speak about it? Here's what I think we need, and here are the mechanisms and timing of which I think we can get it. What's your reaction to that?
I'm excited. I'm excited because you've just made my life easier, right? And that's really partners in firms. They want associates to make their life easier because they've got so much on their plate. So if you come to me with an actual discovery plan of not only written discovery, but then what are the next steps that we're going to do, I'm ecstatic. And I'm thinking, this is somebody who I want to give more work to. This is someone, when I get a new case on my desk, I'm going to say, I want Matt to work with me on that case because I know he's going to make my life easier.
And that's not something you probably think of with a new attorney, that you're automatically going to have that trust. But what you've shown there is two things. One, that you can think about the case in a bigger picture. How can you do that? From the jury instructions, because we've already thought about what we actually need. So the jury instructions have now provided our roadmap to what we need in discovery. And you're also thinking more globally about the case. And that is so critical and difficult, which we'll talk about a little bit later for new attorneys. So tip one, utilize jury instructions. The second thing you can do immediately is learn how to create effective discovery plans and then execute them as well. But it all starts there and then everything kind of flows from that. The third thing that you can do to be successful as a new litigator, and this is difficult and it's going to take some time, is learn how to take an effective deposition. Depositions are different than you think that they are, and they can require a lot of time in order to be, skillful to do.
To develop those skills. It's true. And I think you want to take advantage of whatever opportunity you have to expose yourself to different types of attorneys taking depositions. And I will tell you, when I first started and I was waiting for my bar results, I was working at a temp job as a paralegal and I was doing depo summaries. I thought it was so boring. But once I got my bar results and I got my first job as an attorney, it was such a resource for me because I was thrown into depositions rather quickly. It was a smaller firm.
Right.
It was great, but I was able to pull on what I'd seen in those depo summaries to understand what is a good deposition question? What's a bad deposition question? I had a better appreciation for timing of certain lines of questioning. Yeah. And so I think taking advantage of whatever opportunities might present themselves to summarize depositions, to sit in on a deposition for a couple of hours, even if it's not billable time, but to be able to see someone take a deposition. And it will teach you two things. It will teach you what's an effective way and what's not effective, because you will see attorneys that are really great at taking depositions, and then you'll see attorneys that really aren't great. And for me, a lot of it comes down to preparation.
And when
you've been prepared.
And when you are looking in transcripts or observing people, keep an open mind, because oftentimes we assume that this person is, they're a very experienced trial attorney. They have to know how to take an effective deposition, and I need to emulate them. But that's not always true. And it's not necessarily a comment on their skill. It could just be they're too busy to really prepare. They're at a different place. So make sure you're paying real attention to the questions and think about yourself. How would I ask that question? Because you are going to develop your own style over time, but it's going to take time to do that. And so think about how you'd approach it, what you would do differently, so that when you do get that opportunity, you have an idea of how you're going to do it. And as Cynthia said, it comes down to the preparation.
Yeah.
You want to make sure that you give yourself enough time when you get the opportunity to take the deposition to prepare thoroughly. It's not the day before I'm thinking about it. It's not the morning before I'm thinking about it. You want to give yourself enough time to look through the case file, the exhibits, see what discovery's out there. Maybe if you have enough time, see if there's some discovery you want to do beforehand strategically that might be beneficial for you. You want to create an outline. You want to think strategically about the questions you might ask. All those things are not something that takes place over a matter of hours. It takes place over time. So you want to make sure that you're giving yourself enough time to prepare to take a deposition. Now, we could spend, in fact, we have spent hours talking about preparing to take depositions and taking depositions. You can find our courses like that on elitelitigationtraining.com or on our platform. Unfortunately, we're a little strapped for time today, but no, taking an effective dep is a great skill that you can develop over time. And not only will it set you apart early, it'll set you apart later too.
And I think the key is really getting to a point where, look, preparation can be hard. Being a litigation attorney is time consuming. Your days will run by and you'll find, oh my gosh, I have the deposition at the end of this week. But find that time to prepare, because essentially you want to be in a position where you're walking into that deposition knowing exactly what you need from this deponent. You know what are the admissions you need, what are the statements you need from this particular witness that are going to go to certain issues, certain causes of action, or certain defenses. And if you've done that, you're really going to be effective and efficient in your deposition. I remember one deposition where I prepared pretty well, and about halfway through the deposition, we took a break, and plaintiff's counsel said, hey, can we talk for a minute? And I said, sure. And he said, I can see your motion for summary judgment coming together. And I said, yeah, I can too. And he said, hey, why don't we talk about how we might be able to get this case wrapped up? And we suspended the deposition, and we ended up resolving the case because the deposition was going so effectively, because I prepared and I was able to get really good admissions from that particular deponent. And honestly, I think part of that was because the attorney had to prepare the deponent.
Well, that goes both ways.
So yeah, it definitely goes both ways.
But that's worth the comment right there, because Cynthia had effectively prepared for that deposition for a couple of reasons. Number one, she knew the elements of the case. She had already prepared by looking at those jury instructions, and she knew exactly what she was going to do. How did she know that? She had a great discovery plan. And because she had a great discovery plan, she had the information necessary to incorporate with the elements of the claims to go into the deposition looking forward. So the preparation of the things that we've talked about before, you're starting to see how that sequence moves forward.
And preparation can be so key also, because we might be limited in the time that we have to take a deposition.
Yes.
Federal courts are generally going to be limited to a set amount of time. Certain state jurisdictions are also going to be limited as well. So you really need to make sure that you're judicious with your time in deposition and you're using your time efficiently to get what you need.
So learn how to take an effective deposition. That might require you to invest some time to just be somewhere, volunteering to be somewhere without billable time or without getting credit for what you're doing, but you can learn. And that's important, because that will lead you further down the path.
Absolutely.
Tip number 4, learn how to draft and oppose motions for summary judgment. Motions for summary judgment, Cynthia, is one, frankly, of the most powerful tools available to a litigator. And we say motions for summary judgment, but we're also talking about is motions for partial summary judgment. And in some jurisdictions, they call that motions for summary adjudication, which means you get part of a case knocked out. That dynamic of an effective motion for summary judgment or partial summary judgment is a game-changing thing for a case. Even filing an effective motion for summary judgment can be something that generates settlement or generates the other side to take a different position on the case. So if you are able to learn how to draft and oppose a motion for summary judgment, that is a critical skill. And frankly, that's a skill that is going to be difficult for new litigators because it's difficult for very experienced litigators. Now, we could spend tons of time talking about motions for summary judgment. We have a separate class on that. We talk about it in our boot camp course. There's a lot of things that go into drafting and opposing motions for summary judgment. We want to talk about one thing today, and it's maybe the most critical thing.
Yeah.
And that is knowing what a material fact is. Cynthia, talk to us about material facts that are important to what they are and how they relate to motions for summary judgment.
No. Understanding that concept is so important because not every fact in a case is going to be a material fact. A material fact is a fact that goes to an issue or a cause of action or a defense in the case. There are other facts which may be important, which may be contextual facts, but they're not material facts. So understanding that distinction is so important because think about it. A motion for summary judgment, you're asking the court to rule in your favor as a matter of law because the court cannot rule on issues of fact. So you're saying, Your Honor, all of these facts, assuming they are true and undisputed, we win as a matter of law. Okay, so if you're the moving party, you want to try to limit the number of material facts that you are asserting because then you're limiting the number of material facts that can be disputed. Yeah. It's really important to understand that.
And talk to us a little about what is a material fact.
Yeah, the material facts are facts that go to prove or disprove, right? Yes. An issue or a cause of action or a defense in the case. So understanding that is central. Obviously, if you're a moving party, moving for summary judgment, you're trying to establish that these are undisputed material facts. If you're the party that's trying to oppose the summary judgment, you're trying to show that no, these are disputed issues of material fact. So opposing a motion for summary judgment, you need to go through each material fact and all of the evidence that's cited in support of that material fact to determine, is the evidence objectionable? Is it evidence that actually supports the proposition that they're putting forward? Is it evidence that supports the finding of that fact? And if it doesn't, then it's a disputed fact.
Yeah, absolutely. Yeah, I think Cynthia mentions contextual facts, and there's so much confusion about what a contextual versus material fact is. I have seen a motion for summary judgment that I had to oppose that had close to 700 material facts, almost none of which were material. But think about how consequential that is for the person who's drafted the motion. It wasn't particularly hard to have identified disputes of fact, which means that person just wasted a ton of their own time, but more importantly, their client's time and their client's probable money. And so you want to really learn how to determine what a material fact is and a contextual fact is what we call it. Now, once you learn to do that, that's not the entire battle. You also need to learn how to specifically craft that material fact in a way that doesn't leave much leeway to see if it can be disputed.
Yeah. It's very time consuming. I think that's the other thing that's important to appreciate about motions for summary judgment. These are not motions that you craft on the fly. You think, hey, yeah, let's just put one together and see what happens. They're motions that require a lot of time. Yes. Depending on who is involved in the process, you need to build in time for review by other partners, other associates, clients. So knowing that this is a heavy lift is important, but it's something that you want to be looking at every case, because maybe there's a case where you understand there's a lot of issues of disputed fact with respect to this cause of action or that cause of action, but we believe that the plaintiff cannot meet their burden on punitive damages. So let's just move for summary adjudication on punitive damages. Imagine how impressed your client is going to be if you're able to get that out. On the flip side, imagine how impressed your plaintiff client is going to be if you oppose and win against a motion for summary judgment. They are leverage changers in cases. They can impact the value of a case, and they can shift momentum on the drop of a hat or an order.
But a motion for summary judgment, though, is not something you think about just after you've completed discovery. A motion for summary judgment is something you have to really consider very early on in the case, because if there's an opportunity, you got a small one, to file a motion for summary judgment, a partial motion or a motion for summary adjudication, that has to be incorporated in our discovery plan. That has to be something that we specifically address in deposition. So you really need to start thinking about whether there's an opportunity to file a motion for summary judgment early on. And you can do that. It ultimately might not come to fruition, but you can prepare your case as if you have that opportunity. And what's the loss of that? If nothing else, if there's not that opportunity, you have well prepared your case for trial, which is what you should be doing in every case anyway. So think about motions for summary judgment early on. A second part to that is some jurisdictions require you to file motions with an extreme notice period, and that can affect your motion filing deadlines. It can affect how you do discovery in order to get to that point. So know the rules of your jurisdiction with respect to the motion for summary judgment when you're considering one, because that can be a very dynamic thing in terms of how you prepare and how you prepare to file the motion. So that's the first 4 tips. You can see all these things build upon each other. And those first 4, if you just do those first 4, you're really going to start setting yourself apart. But let's give you one more. And that is, think about how the work that you're doing fits within the greater case. And that is something for new attorneys that's exceptionally hard, because oftentimes an attorney will walk into your office and say, hey, can you just draft me some discovery? Hey, can you prepare a memo? Can you do some research on this? Can you do this? But we challenge you to think about how just that one assignment will fit into that case as a whole, and how the work that you're doing can help shape that case in a successful fashion. Now, at a legal litigation training, we like to think of the litigation process as a puzzle. And so we look at jury instructions as a piece that fits within how we prepare our discovery plan. And after that, our discovery plan, the piece fits with how we do depositions, which then is related to motions for summary judgment and trial. The pieces of the litigation puzzle fit together, but oftentimes when we're stuck doing one
isolated project,
we can't see it.
Yeah, it really is hard to see. And I can tell you, as a newer attorney, that's something that I struggled with. I don't think I felt comfortable really understanding all the different components of a case or what I needed to do to move a case forward until I'd been practicing for probably about 5 years.
Yeah.
So it takes time. We hope that these 5 tips really give you the ability to kind of look at how can I move my career forward faster. But if you're looking for something in depth, we have a wonderful program coming up that really goes into a deep dive into all of these 5 tips and more.
Yeah, Cynthia references this, but one way you can sort of expedite this process is training and investing in yourself in thorough and detailed training sessions that will provide you skills and perspective. So, for example, Cynthia and I have a course that's called ELT Bootcamp, where we cover everything in the litigation process from initial client intake all the way to judgment collection, and everything in between from the plaintiff and defense perspective. And you say, what might that do for me? Well, we teach you specifically how to put the pieces to the puzzle together while teaching you the technical, the practical, and the strategic skills on how to do that. That's a training that would be something worth investing in. There's other courses like that too. You want to make sure that when you're looking for opportunities to get these training courses, that they're teaching you a specific skill and detail, that they are providing you the greater perspective. A lot of us get to an NCLE deadline or something like that. We just take some classes.
Right.
And that's okay if you have to do it, but really invest in yourself and in your skills, because the investment in yourself and in your skills is really going to help you to move forward faster. And we keep saying that. Why do we want to help you move forward faster? Because being a litigator is a great career, and it can be a very interesting and exciting career. But those first few years can be frustrating. Cynthia referenced how long it took her. I had to try my first case before I walked out of that courtroom, and fortunately it worked out for my client. However, I said when I got back to my office, I did so many things wrong because I didn't have the end game in mind. My perspective wasn't shaped appropriately because I didn't have the opportunity to take courses like we put together, or thorough training courses as they are. So we challenge you to invest in yourself, but more than anything, take these 5 tips. These 5 tips alone, when you break them down, you really dig further into them, they will help you transform your career. We really appreciate you being with us today, and we look forward to talking to you again soon.